Members, it's the appointed time and we have a quorum. I call to order the meeting of the Bills Committee on Registration of Same-Sex Partnerships Bill. This is our fourth meeting. We will now carry on with the clause-by-clause scrutiny of the bill. Deputy Secretary, please walk us through clauses 16 to 18. Thank you. Please turn to C3798 of the Chinese text and C3799 of the English. Subdivision 2, Same-Sex Partnership Revocation of Registration Certificate. Clause 16, Preparation, Issuing, Filing and Registration of Same-Sex Partnership Revocation of Registration Certificates. This is the same as Clause 9, except that Clause 16 applies to those who apply for revocation of registration certificates. A set of 3 copies will be issued. Both parties of the partnership will each get a copy, and the third copy will be kept by the registrar. Clause 17, Effect of same-sex partnership revocation of registration certificates or their certified copies. That means these certificates will have their legal effect, and this is the same as Clause 10. Clause 18, Correction of errors in same-sex partnership revocation of registration certificates. The registrar has to authenticate the correction by his signature or by marking his initials. And this is the same as Clause 11. One member has asked to speak, Mrs. Regina Ip. Chairman, these clauses give rise to the same set of questions as to the previous clauses. That is, will these certificates or documents be made public? Are they so secretive that they cannot be made public? Also, if there are errors, why not issue another set of certificates instead of making the errors on the original copy? This is a question for the administration's consideration. Yes, legal advisor. I'd like to seek the administration clarification on this. Can either of the party make correction of the errors denoted in the certificates? Deputy Secretary, any party may raise questions about the certificates, but of course we will verify what kind of information is involved in the errors indicated. Well, if there are no further questions, let's move on to Clause 19. Deputy Secretary, please. Page C3800 of the Chinese text. Division 3, Nullity of Same-Sex Partnership Registrations. Clause 19, Recognition of nullity of same-sex partnership registration by registrar. If the registrar, based on certain information, is satisfied that the partnership, when being registered, that one or more than one of the conditions mentioned in Section 6 were actually not met, then the registrar can take the initiative to revoke the registration. If that's the case, the registrar will issue a written notice of the nullity of the registration, and to avoid doubt, a same-sex partnership registration recognized as null by the registrar under subsection 1 is void from the beginning. On this clause, I see that no members have raised any questions. Let's carry on with the clause-by-clause scrutiny. We now come to clauses 20 and 21. Deputy Secretary, please. Thank you, Chairman. Please turn to C3804 of the Chinese text, Part 4, Offences and Penalty. Clause 20, Tampering with records. A person who willfully removes or alters any document kept or filed, regardless of the form in which it is kept or filed, but the registrar under or for the purposes of this ordinance commits an offence and is liable on conviction to a fine at level 5, that's 50,000 Hong Kong dollars, and to imprisonment for 2 years. A prosecution for an offence under subsection 1 may only be started before the end of 6 months, beginning on the date on which the offence is discovered by or comes to the notice of the registrar. Clause 21. Duty to notify termination of same-sex partnership registered outside Hong Kong. If the same-sex partnership registered outside Hong Kong on which a same-sex partnership registration relies has been terminated, the parties or a party to the registration must notify the registrar in writing of that circumstance within 6 months after the date on which it arose. If this is contravened, the party will be liable on conviction to a fine at level 3. Bracket 3 and bracket 4 state that if any party to the registration can raise any reasonable excuse, then they can have the defense established. Ms. Nixie Lam, I'd like to ask about whether the offences will be set out more clearly for tampering with records. This has to do with forgery of documents. Will you set out the penalties more specifically? It says here a level 5 and a 2-year imprisonment. And which legislation or penalty are you benchmarking here? I'll defer to Ms. Phyllis Wong. I thank Ms. Lam for the questions. Tampering with records. A person who, without authorization or unlawfully removes or tamper with any records or documents will be criminally liable, and the document concerned may be in digital form or in paper form. There have been cyber attacks recently, and any tampering with the records may be unfavorable to the applicant, so we target these unlawful acts under this provision, and the same level of penalty, that is a level 5 fine, $50,000, and a 2-year imprisonment, is imposed in other legislation for the same type of offences, and this is to protect the integrity of the system, and we also have to ensure that the registrar will have enough information and document to carry out his or her duty. I have a supplementary question. Just now you mentioned about digital forms of the document. Say there are people who claim that A and B have obtained the registration, and if the people tampered with the records, will they be governed under this provision? Yes. So anyone who alters the document or the digital form of the documents, they will be made liable? Well, because there are many pranks online. Yes, correct. Mrs. Regina Ip. I have 2 questions, but the first question has been asked by Ms. Nixie Lam. My second question concerns clause 21, bracket 3. If the parties fail to notify the registrar within 6 months' time that the registration obtained overseas had been terminated, there could be a defense. For example, the parties fell ill. Bracket 4 says that a person is taken to have established a matter that needs to be established for a defense under subsection 3. If A, there is sufficient evidence to raise an issue with respect to the matter, and B, the contrary is not proved by the prosecution beyond reasonable doubt, Is this commonly seen in other legal provisions? A reasonable excuse can be made by the person concerned. Will you usually add this phrase that the contrary is not proved by the prosecution beyond reasonable doubt? Does it have to be this strict for the defense to be established? Is this commonly seen legally? DOJ, Mr. Moy, I thank Mrs. Ip for the questions. To address the questions, this provision is commonly seen in other legislations. This provision provides for a criminal offense and a statutory defense for the defendant, assuming that the person will have to prove to be innocent, and we give the possibility that the person can establish a defense. So bracket 4 here states that as long as the defendant can raise sufficient evidence, that is the reasonable excuse as mentioned in bracket 3, then the burden of proof will fall on the prosecution. And according to our legal system, the prosecution has the responsibility to prove the contrary beyond reasonable doubt. For example, the prosecution has to prove that the defense made by the defendant is unacceptable or is intrinsically impossible. So this is to abide by the principle of presumption of innocence. Legal advisor. Clause 21 states that the parties or a party to the registration has the responsibility to notify the registrar that the registration obtained overseas had been terminated. Does that mean that after the parties have informed the registrar, then the registrar will be notified that the registration obtained overseas has been terminated, and the registrar will, in accordance with clause 14, take the initiative to revoke the same-sex partnership registration instead of asking the parties or party to the registration to revoke the registration themselves? Ms. Phyllis Wong. I thank the legal advisor for the questions. According to clause 21, if the registration obtained overseas is terminated, then within 6 months' time, they will have to notify the registrar. According to clause 14, the registrar has the power to take his own initiative to revoke the registration. So whether it is the applicant who applies to revoke the registration or even without the application made, the registrar has the power to revoke the registration. So here we are not making the party or parties to responsible for the revocation.
Deputy Secretary, Part 5 Miscellaneous Provisions on page C3809 of the English version. Power to allow searches and give certified copies, etc. The registrar may allow searches to be made amongst instruments in the registrar's possession for the purposes of this ordinance. may give a certified copy of any entry in those instruments and may issue a certificate to the effect that there is no record of any same-sex partnership registration of a person named. The registrar may charge a prescribed fee for a matter mentioned in subsection 1. So in C3A15 to C3A19, we have some prescribed fees set out. Mrs. Regina Ip. Thank you. The registrar may allow searches to be made amongst instruments in the registrar's possession for the purposes of this ordinance. There is significant power. The registrar may approve any person to do so. This is an enabling provision. This may be against the legislative intent. If we are going to provide regulation by way of subsidiary legislation. Thank you, Deputy Secretary. For the instruments that the registrar may allow searches to be made, mainly we target applicants or third parties authorized by the applicants. We tread cautiously, and we also consider reasonableness. So why don't you set out clearly? Why don't you set out the fact that you will only approve when the application of inspection is made by the relevant authorities or by the relevant parties concerned as mentioned? Thank you, Mrs. Regina Ip. At this stage, that is the drafting stage, we want to maintain flexibility. We want to keep it flexible for the registrar to exercise his or her power, having regard to the operational needs and the actual circumstances. Thank you. No more members would like to ask questions on this. Let's move on to Clause 23, disposal of documents recorded in form of digital image. The registrar may, in a manner that the registrar considers appropriate, destroy or otherwise dispose of any document that has been recorded in the form of a digital image under this ordinance. Any question on 23? No. Let's move on to Clause 24. Deputy Secretary, please. Thank you, Chairman. Clause 24. Issuing certificates or notices by post. If the registrar is required to issue a same-sex partnership registration certificate or a same-sex partnership revocation of registration certificate to a person, and the registrar is satisfied that it is not reasonably practicable to issue the certificate to the person by a means that is more effective, the registrar may, for issuing the certificate under this ordinance, send the certificate to the person by post addressed to the person's last known address. Mr. Kenneth Leung. Thank you, Chairman. Just now, as the Deputy Secretary said, by post addressed to the person's last known address. So what if the certificate, especially the revocation of registration certificate, cannot be posted to the party concerned? How are you going to deal with it? Well, we post by register post the certificates we issued. Therefore, we have a record of the post. We also hope the relevant parties will receive the documents. However, if the persons concerned do not receive the documents, we will see if the person has left with us any other means of contact, such as email address or a mobile phone number. We'll try to get a hold of the applicant concerned. If we still fail to do so, We will keep a record and contact the person concerned if need be. Chairman, I have a question myself as well. Sometimes the post box is in a village house or outside. Registered post may be safer, or the person concerned may authorize someone to pick up the letter in the flesh. This will prevent misunderstanding. Probably you have already mailed the letter or the certificate, but then they were not delivered to the intended recipient by mistake. You may want to offer double protection in order to prevent any misunderstanding or accident. Thank you. The following provisions are quite simple and straightforward. May the Deputy Secretary take us through clauses 25 and 26 together? Thank you. C3811 in the English copy, Clause 25, Amendment of Schedule 1. After the implementation of the mechanism, if there is a need to review the fees and make adjustments, we recommend the Chief Executive in Council may amend Schedule 1 by notice published in the Gazette. That will be done by negative vetting through subsidiary legislation. Clause 26. Secretary may make regulations. The Secretary may make regulations for the better carrying out of this ordinance. Dr. So Cheng-Wing has pressed the button to request to speak. Dr. So, please. Thank you. A quick question about Clause 26. Does the Secretary need to consult the Legislative Council when he makes regulations? Yes. When the Secretary makes regulations, he will have to consult the Council. Thank you, Legal Advisor. Thank you, Chairman. Members, please note. For Clause 25, only amendments to Schedule 1 need to be published in the Gazette by notice by the Chief Executive in Council. Clause 26. The Secretary may make regulations, but then the regulations aren't set out in this bill. Administration, I will ask Ms. Wong to take these questions. Thank you, Legal Advisor, for your questions. Legal Advisor just now talked about Clause 25. The CE in Council may amend Schedule 1 by notice published in the Gazette. This is in comparison to Schedule 2. Schedule 2 is about specified relationships. It's recognized by the laws of Hong Kong. The likelihood for it to be amended is slim. That's why it's not covered under Clause 25 in relation to the amendment of Schedule 1. When it comes to regulations under Clause 26, we don't set out such regulations in the bill. The operation of the mechanism is about administrative details or implementation. It's not very complicated. It doesn't have to do with a lot of details. So we don't propose to set out such regulations under the bill. However, upon the passage of the bill, if we find it necessary, we will set out the regulations here. If there is no further question, let's continue with the examination. clauses 27 and 28. Deputy Secretary, can you take us through these two clauses together? Thank you. Clause 27. Secretary may specify form of documents. As we mentioned, the registration mechanism requires applicants to submit information and documents. We will request information of different types as well as proof. We empower the Secretary to specify form of documents under this bill. Clause 28. Related amendments to certain enactments. The enactments specified in Schedule 3 are amended as set out in that schedule. We propose a total of 6 existing enactments will have to be amended. All right, members, any questions? I have one question I'd like to ask the administration in relation to Clause 27. The Secretary may specify form of documents. Well, does it actually have to do with the registrar? The division of work is very clear. I'd like to know if this is unusual practice. For documents, do they include registration certificates or revocation of registration certificates? Thank you. Regarding form of documents, we have noticed similar arrangements under other pieces of legislation. The Secretary is empowered to make such decisions. And of course, the registrar is authorized and empowered by the Secretary to be responsible for the operation of the registrar's office. When the office is set up in the initial stage, decisions will be sought from the Secretary. Afterwards, the registrar will implement the arrangements together with officers in the office. All right, thank you. Let's move on to Schedule 1. Deputy Secretary, please. C3815 of the English copy. Schedule 1 prescribed fees. Making of registration application, there will be a fee. For revocation, a fee as well. When one applies for a certified copy, this is acceptable at a fee. When there is a request for a search, there will also be a fee. When one wants to apply for a certificate to prove that there is no registration, we will also issue such a certificate at a fee. All right, Mrs. Regina Ip, thank you. I'd like to know how you determine these fees. Are they determined based on the principle of cost recovery? If so, the costs are actually quite high. And I'd like to know, as for item 3, without the object of the search being specified, why is it so much more expensive? And regarding certificate under Section 22, Brackets 1C of absence of any record of same-sex partnership registration, $545. Why is it so expensive? Deputy Secretary, thank you. We've drawn reference from the charging of fees of the government to determine these fees. Administrative costs are included, such as manpower. It also covers support. These fees have been approved by the FSTB. In relation to searches, we need to take into account the nature as well as the requests. If the searches are quite simple and straightforward, then the costs will be lower. However, if the searches are about more items, then the costs will be higher. This is the arrangement we project. In relation to certificate of the absence of any record of same-sex partnership registration, the cost is higher because we'll have to retrieve more files in order to issue this certificate. We need to rule out different types of information to ascertain the absence of any record of same-sex partnership registration. Thank you.
Let's move on to Schedule 2. Deputy Secretary, please. Specified relationships. This is one of the conditions to be met if same-sex partners would like to have their partnerships registered. And this has to do with the 6 conditions. We ask that the parties to the registration should not have any relationship by blood. This has to do with social ethics. For example, we have given definition to child of the family and children of each other's or children of their partners. Dr. So Chun Wing. I'm looking at point 5 under relationship specified for section 6 and part 3 relationships mentioned in part 2 of this schedule. I want to know if the administration can use, for example, tables to explain these relationships for easier understanding. Ms. Wong, I thank Dr. So for the questions and the comment. If this law is passed, we will issue clear guidelines for members of the public's reference. We will consider using tables to explain these relationships. Well, I myself have a question about Schedule 2.4. This could be rather complicated. The younger party to the same-sex partnership registration application has not at any time before reaching 18 years of age been a child of the family in relation to the other party. Well, I don't quite understand this part of the provision. Can you explain, please? Thank you, Chairman, for your questions. To give you an example, Part 3, Division 2 sets out the relationships that cannot be registered. Say, for example, there is a man and he wants to obtain a registration with another man, and the man might be the son of his former partner. Part 3, Division 2 includes this relationship, stating that this relationship is not acceptable. And Part 4 sets out the exceptions. To give you an example, say a man is forming a partnership with the son of his former legal partner. As long as this man and this son does not have a father-son relationship, that is, this man is not treating this son as a biological son or a son, then this kind of relationship will not be restricted under this registration system. Well, I'm not sure if my understanding is correct. The idea is to prevent incest. So will this man and the son has to be related by blood? Well, if that's the case, they won't be able to obtain registration. Even if they are not related by blood, we have to ensure that this boy, when he was before 18, he was not living with the man. As long as this situation does not exist, then we consider that they are not in a father and son relationship. Then this kind of relationship will not be restricted under the registration system. Well, this is rather complicated. I think the administration will have to be very patient in order to explain clearly this concept to the public. Yes, Dr. So Chen-Wing. I want to ask this question riding on what the administration has just said. I'm not clear about part 2 and part 3. Just now the chairman asked about point 4 of part 2, and the DOJ said it's not considering whether they are in relationship by blood, but it considers ethical issues. In the past, we only consider this kind of ethics for traditional marriages, but how come you make this so complicated even under this same-sex partnership registration system? Deputy Secretary, I thank Dr. So for the questions. We have to establish a registration system in order to recognize same-sex partnerships, and this is because we have the positive obligation to do so according to the judgment made by the CFA. We have to consider the actual circumstances in Hong Kong. We also have to take into consideration traditional values and social ethics when we form this registration system. So we have to incorporate all these elements into the proposed system. We think the proposed arrangement is appropriate. Well, I see that there are many different kinds of relationships set out in this schedule. Did you make reference to other countries when you formed this schedule, or is it based on your own idea? Chairman, we made reference to the marriage ordinance when we list out these relationships. Understood. If there are no further questions, we now move on to Schedule 3. Members, please refer to the marked up copy, LC paper number CB bracket 2 1497/2025 bracket 01. It's a marked up copy prepared by the administration. Deputy Secretary, please walk us through the marked up copy. Based on the judgment made by the CFA, we have the positive obligation to establish an alternative framework, and at the same time, we have to confer on them certain rights. So after prudent consideration, apart from the registration system, we decided that we have to confer on same-sex partners certain rights. We can confer on them these rights through existing legislations as well as administrative measures. But we have to, in order to do so, amend certain ordinances. That's why we are proposing to amend 6 enactments. And the amendments have to do with the definition of same-sex partners and the rights for same-sex partners to deal with their partners' medical-related matters and death-related matters. Well, should I go through them one by one now? Yes. Well, please let members know of the key amendments. C3828. Interpretation and General Clauses Ordinance. We consider adding the definition of registered same-sex partner and same-sex partnership registration into Cap 1. This is a technical amendment. Please turn to page 1 of the marked up copy. Well, perhaps we just look at the marked up copy now. Sure, page 1 of the Chinese marked up copy. On the left-hand side, you see a triangle here, and so you can see on the right-hand side the relevant amendment. That is, we are adding the definitions of registered same-sex partner and same-sex partnership registration to Cap 1 of our law. Please turn to page 2 of the marked up copy. Cremation and Gardens of Remembrance Regulation, Cap 132, Subsidiary Legislation M. We will allow same-sex partners to have the right to apply for a cremation permit. So we are amending Section 4, subsection 1b of the ordinance. We are adding the phrase including a registered same-sex partner so that they have the right to apply for a cremation permit. Members, if you have any questions, please press the request to speak button. Please turn to page 4 of the Chinese text. Part 3. Medical, Therapy, Education and Research Ordinance, Cap 278. We are adding the phrase spouse, the surviving registered same-sex partner here, so that the surviving same-sex partner could decide how the body of his or her deceased partners be used. Yes, Mrs. Regina Ip. This part is to amend the Medical Therapy, Education and Research Ordinance. Does this have to do with the donation of organs? Yes, this is included. This has to do with organ transplants of the deceased as well. Now please turn to page 5. Part 4, Human Organ Transplant Ordinance, Cap 465. The reason to amend this ordinance is to allow same-sex partners who have maintained their relationship for at least 3 years, then they can decide or they can make decisions to transplant their organs. Mrs. Regina Ip, I have a very simple question. Why do you ask the same-sex partners to have their registration subsisted for not less than 3 years? We traced back the legislative intent and spirit of enacting this ordinance. It is to prevent bogus marriage or bogus arrangements. This is to ensure that the partnership has been maintained for 3 years in order for the organ transplant to take place.
I, page 0006. Section 5A repeal subsection 4. Two persons are not regarded as spouses whose marriage has subsisted for not less than 3 years, unless the fact of that relationship has been established by a means prescribed by the Board by regulation. Then page 008, Part 5, Human Organ Transplant Regulation, Cap 465, Subsidiary Legislation A. Section 2B added after Section 2A. It's about the implementation details. The spirit is the same as above. Establishment of same-sex partnership registration that has subsisted for not less than 3 years. Only then may organ transplant be conducted. Page 0010, Section 6, Schedule amended forms. Bottom right corner, you will see the requirements being added. The applicants will have to mark these according to their own conditions. Schedule Form 1 Part 1 Paragraph A3. In addition to the existing practice, we substitute a paragraph by including registered same-sex partners. Then page 0019. Right bottom corner. The application form and the supplementary documents and proof will have to be submitted for verification. Implementation details are added here. Then page 0020 is about organ transplant. Schedule Form 2 Part 3. After A3, we include registered same-sex partners as well. Same text, is that right? Yes. These are technical amendments. Thank you. Please move on. The last ordinance to be amended. Please turn to the last page. 0022, Part 6, Personal Data Privacy Ordinance Cap 486. We propose to amend Section 63C, Emergency Situations. If registered same-sex partners are in life-threatening situations, there will be exemption from the Personal Data Privacy Ordinance. The situation of the person concerned will be related to the registered same-sex partner. Thank you. Alright, we have already gone through Schedule 3. The Secretary for Constitutional and Mainland Affairs will move some amendments in relation to Schedule 1. Will Deputy Secretary take us through these amendments? Thank you. We received comments from the legal advisor. there are a few areas which we will have to amend in order to improve the clarity of the provisions. That's why we have taken on board the views of the legal advisor. We have provided a document to the Secretariat. Later on, we will propose committee stage amendments. I'd like to take members through our CSA. Please continue. Under Schedule 1, C3814 of the Chinese version and 3815, you will see top right corner section or subsection 2 and 23. We will amend 23 to 25. C3816 under column 3, in order to make it clear, we'll change the word copy to certificate. C3817, column 3, we change copy to certificate to reflect our intention. These are the three intended amendments. Mrs. Regina Ip, please switch on the mic for Mrs. Ip. I'm not sure if I missed any CSA to be moved by the administration. Clause 2, making of an application for revoking a same-sex partnership registration under section 12(1) or 13(1). It doesn't match the Chinese text. You didn't mention under the law. Same-sex partnership registered outside Hong Kong. The spirit of this bill is same-sex partnership registered outside Hong Kong. That is the spirit of this bill. Please switch on the mic. Miss Lam. Well, actually we have used a sandwich approach to express the meaning. This will be more coherent in English. All the elements are actually covered, just the way we express it is different. Well, I think it'd be better if we make it clear it's done in accordance with law. The Chinese and the English version should match one another. In the English version, under the law of a place outside Hong Kong, that corresponds to the Chinese version, just that we use a sandwich approach. Well, I want to record my point. As long as the form is recognized in an overseas jurisdiction, it should likewise be recognized by Hong Kong. Thank you. I want to have my point recorded. Thank you. We have already finished the clause-by-clause examination of the bill. Legal advisor, please confirm if there is any issue in relation to the English text of the bill. Thank you. In addition to the question raised on the 22nd of July, we wrote a letter to the administration. We don't have any other questions. Alright, we have already finished a clause-by-clause examination of the bill. If members agree, we will circulate the relevant information. We will circulate the following documents to members for reference. 1. The consolidated response from the administration on public written submissions and the administration's written response to the issues raised by members, if any, and the proposed CSA to be moved by the administration, if any. Members, if you would like to make any CSA to the bill, and if you want the Bills Committee to consider your amendments, please do so. Submit the relevant draft to the Secretariat by 5 p.m. on the 28th of July. The Bills Committee will decide whether we will convene another meeting to discuss the documents mentioned above. Let's see if members have any more questions. Any other business? No. After the Bills Committee completes the scrutiny of the bill, well, Mrs. Abe, I have a simple question. Are all public submissions accessible online? Can they be accessed online? Well, basically all of them can be accessed online, unless if the representatives requests not to disclose their submissions. But just a small number of them, and the deadline is 5 p.m. tomorrow. After the Bills Committee finishes all the scrutiny work, we will make a report to the House Committee. I'd like to ask the Secretary and the Deputy Secretary. The intended resumption of second reading debate at the Council. Secretary. Thank you, Chairman. Well, the CFA requires we set up an alternative framework by the 27th of October. We want to pass this legislation in order to set up the alternative framework. In order to fulfill our obligation to finish setting up the alternative framework, I hope the Bills Committee will submit a report to the House Committee as soon as possible so that we can resume the second reading debate of the bill as soon as possible. Thank you, Secretary. So, members, any views on the date of the resumption of second reading debate? The first meeting, 28 questions. The second meeting, 17 questions. The third meeting, 16 questions. We have held a few meetings. Any more questions? Secretary. Well, including policy discussion, we have held a total of 4 meetings. That includes policy discussion. Yes, indeed, 1 meeting for policy discussion and 3 meetings for the examination of the bill. In the first meeting, members were very active in asking questions and expressing views. Any other business? No. Meeting adjourned. Thank you, members.